Hello, everyone. This is Attorney Gehi and from my legal software, and I have Rahul with me, and we'll be starting in the next 1 minute. So, if your friends or if anyone wants to join, today people are going to learn a lot and about federal rules of civil procedure, and in particular, we are going to talk about a very important rule, and this rule can be important for seasoned lawyers who practice federal law. It can be good for people who are new to federal law and people who are at an intermediate level. So what we've decided to do is we're going to pick a little from everywhere so that we all have a very good understanding of what is Rule 11. And Rahul will be kind of talking a lot in between. And we'll start with the basics. And I'm going to give my practical points, and then after that, Rahul will cite the rules, and we'll somehow try to make it a win-win for everybody. And if you have any questions, you can also, go to a chat box and send us some questions. And what is Rule 11 meant for, really? Even if you're basically, practicing in federal court in any capacity, you may be a maritime lawyer, you may be engaged in an immigration practice. It may be involving, some other area of practice, such as the Fair Labor Standards Act. Or it may be involving discrimination cases. These are just examples wherein federal law comes in. Or it can be a federal question. It may be based upon diversity jurisdiction, any case in which the federal court has jurisdiction. So for new lawyers, you need to understand the meaning of the word jurisdiction, which is very important in federal law. I'm talking to you from my practical experience. What I've seen is sometimes the court will ask you, what makes you feel that there is jurisdiction in the case? So you need to make sure that exactly you argue jurisdiction very well. Jurisdiction is the authority of the court to hear a particular matter before it. So which means, does the court really, are you presenting a federal question? That's the number one thing for you to understand. Now, why is that important? I'll tell you. So there are some new lawyers who commit this mistake. And what they think is that if I'm going to go to state court, with all these state causes of action. Now, take an example. You're dealing with real property law, real estate law in New York or California or in any other place over here. So the issue might be like, can I take this to federal court? So there are lawyers who think that it would be a great idea if I could take it to federal court and get a quick decision on this case. Now, the biggest mistake you may commit is to file this action in federal court. The reason being is because you're living in the state, you don't have any federal grounds, which means, just talking about someone bought a house, it is a breach of contract case, and you went for the closing, the party did not show up. These are the facts of the case. Nothing more to that. And it's a simple breach of contract, unjust enrichment. Now, both the parties, the plaintiff and the defendant, are living in New York. Now, this smart lawyer thinks that I want to file an action in federal court. So now, Rahul, what will happen in this case? Can you tell me?
Well,
so we start with the word sanctions, straight up. So we don't want to scare people here. So the thing is that be very careful because you're dealing with the federal code of the United States. In essence, you're looking at a court that is not going to tolerate any behavior which is unacceptable of a lawyer who's experienced and a lawyer with good standing before it. So that's the best way for me to describe it, Rahul. Do you have any better ways to describe this?
If we're talking about basically the kinds of filings that are acceptable in court whenever you're making a representation to court, one of the clear things under Rule 11 that they were concerned about are filings that are made for an improper purpose to either cause, a delay or waste judicial resources, or to harass the litigants, or needlessly increase costs for the other parties.
So Rahul, let me give them exactly what are the most important things that the lawyer needs to know about Rule 11. There are penalties imposed on either party or an attorney by the court for the violation of the provision of Rule 11 or the federal rule of civil procedure, representation to court by presenting to the court, whether by signing, filing, submitting, or later advocating, or pleading written motion or other paper, an attorney or unrepresented party is certifying to the best of the person's knowledge, information, and belief formed after an inquiry reasonable under the circumstances. One, it is not being presented for an improper purpose, such as to harass or to cause unnecessary delay or needless increase in the cost of litigation. So, if you're going to harass the court, when you're filing frivolous papers, or if you think that you are a smart aleck and you are somehow trying to gain federal jurisdiction in a case which exactly you know for sure that the court doesn't have jurisdiction, but you're trying to add a cause of action, which the court would definitely say that this is something we don't even expect you to, include this over here, then you're trying to kind of cross the line. That's the first way for you to be careful. So that's why I took the real property example. So you're going to just say, you're going to just put one, federal cause of action just for the heck of it is the best word. That you're going to add something that's, that this person is actually responsible under federal criminal laws for fraud or something. Courts are smart enough. They're going to tell you, hey, listen, it's not going to work here. So don't be a smart aleck. That's number one. Be professional. Do your legal research before you're even going to federal court. That's rule number one. The claims, defenses, and other legal contentions therein are warranted by existing law or by a non-frivolous argument for the extension, modification, or reversal of existing law or establishment of new law. Now, if there is a body of case law that is already existent, and if your facts are exactly the same, and if the court has said that in these cases the court will not have jurisdiction, or the law is clearly set on the point, you're trying to argue the same issue before the court, you're going to be in trouble, folks. Therefore, it's very important for you to make sure that if you're a good federal lawyer, you need to make sure that your facts are very different than the established case law. What are your thoughts on that? And before we go any further, Rahul is a law graduate and he's brilliant in legal research. He's not an attorney, but a brilliant researcher who's more like my law clerk. And as far as I'm concerned, I'm Naresh M. Gehi. I'm the principal attorney of Gehi and Associates. And I'm not speaking in my capacity as the attorney of Gehi and Associates. I'm speaking today in my capacity as the founder of My Legal Software. And thanks to My Legal Software and the staff members for putting this together. And My Legal Software is a case management company, and it's very helpful to any kind of lawyer. GP Speed has been for all general practice lawyers, and there was a specialized version for immigration lawyers. And the company also builds websites for lawyers, which are ADA compliant. So we'll talk about that later, but we thought it's very much important for us to give you a brief background. We need to really thank the staff of My Legal Software, which is a big staff that is putting these webinars together. And and my big thank you to people who have loved these kind of webinars. And we are getting more and more attention from people that they love what we are doing here. So I'll get back to the topic again. So let's get back now. And then between, I'll have to talk about My Legal Software to thank them. So now, I already spoke about the second thing, that when you are kind of going with these frivolous claims in your defense, and when you know that the petitioner is 100% correct, and now if I'm on the defense side, I am interposing false counterclaims. Be very careful. And if I'm the opposing counsel, and if I see that this is absolutely frivolous, as your adversary, I have the right to file for sanction against you. Which means, first I'll make a letter motion to the court. Now, someone is going to ask me right here, what is the letter motion? I haven't heard this term before. Well, you're not the only person who might have not heard this before, especially if you don't practice federal law. So one needs to have a thorough understanding of how the federal court system works. And you should know the procedural law. You should know the substantive law. You should know ECF, electronic court filings. And you have to know the judge's rules. You have to know the magistrate rules. So these are the 5 basic things which I think every lawyer needs to know. Rahul, did I miss anything here?
No, I think those are the
Five basic things. I'm going to repeat for lawyers who are attending, and this will be a very important webinar for immigration lawyers and for, as I said, labor lawyers and people who kind of practice the Federal Tort Claims Act. It's good for federal lawyers on the whole. So these are the five things which I expect new lawyers to know. So make sure that you're ready with it. And now, when you're ready, don't be nervous. But you just need some mentors to teach you if it's your first case, even if you're filing a Monday miss and if you're an immigration lawyer. So make sure that your defenses are perfect. You can just deny the allegations, and you can take it further from there. Now, some mistakes that lawyers do is once if a pleading is served in federal court, you don't just directly answer it like how you do it in state court. We'll get your day in court when exactly you can choose a magistrate under Rule 73. If the other party consents, write this down for people who want to know this. Or if not, you'll have a conference before the judge. It's known as the Rule 16 conference. Now, the Rule 16 conference is very important. And the mistake that a lot of lawyers commit, Rahul, over here, is they do not read the judge's rules. Because the judge is going to be assigned once if a case is filed by ECF, and immediately it's your job to look at the judge's rules. And then you can even reach out to the adversary once if exactly, they've set forth a notice of appearance and ask him, would you consent to a magistrate? So then after that, you can make a Rule 73 statement. Yes, we both are consenting to a magistrate. If you're a new lawyer, I would strongly recommend you to consider a magistrate because magistrates are very nice. They're wonderful. They try to settle cases. And it's a good thing for you to kind of, even if you're a mid-level lawyer who's practiced state court, try to get before magistrate. Trust me, they're wonderful and they love to settle cases. But if your adversary doesn't agree, then remember, on your marks, get set, get ready and go, which means that now you need to be ready with Rule 16. You need to be ready with exactly the initial disclosures and everything and whatnot. Now, over here, what happens is that you file your case in federal court. Now, I'm going to get back to the sanctions issue. You filed your case in federal court. After that, you did nothing. You did not reach out to the other lawyer. You did not read the rules. You don't know exactly what is happening in this case. And you just showed up in court. First time, you may get a warning if the judge is nice. Secondly, he's going to look at your pleading and he's going to tell you one thing, that either withdraw this case. Rahul, I think a person has 21 days, if you know that.
Yes, if there's a motion for sanctions, they have to give you 21 days notice before they present it to the court and give you the opportunity to correct any deficiency. But of course, the court can also, of its own accord, issue an order to show cause for any conduct that they think, violates Rule 11.
See, look at this, how difficult this can be. So now the other side has to make a motion. Either you can withdraw your pleadings, or you can amend your pleadings, or you can change it the way it seems appropriate by researching the proper case law. And even if your adversary is making that motion, don't be scared. It's his job to get it out there, and so that his client has the last laugh. But if the court is literally there, wherein they're already telling you, listen, you're trying to cross the line, apologize to the court right then and there, and tell the judge, I'm ready to work with you. And most judges are very nice. They'll tell you, Mr. ABC, withdraw the case, and that's worth it for you. And the other thing which I've seen is that this is where a good legal software comes in. When you're dealing with federal court, you need to make sure that you keep track of all your deadlines. Now you look at the initial disclosures. What is going to happen when you go there? You cannot just go up and show in the court and show your wonderful face out there. The judge is going to ask you, what is the game plan? How is discovery going to be set in this matter? Rule 26 deals with discovery. Rule 23 deals with, class actions. Rule 68 deals with an offer of judgment. Important rules for you to know. So at the time, the judge wants to know how the discovery is going to move in this case. So after that, once if you're ready with discovery, you put it down by having a very good conversation with the other lawyer. There's a big difference when you're a federal lawyer. Judges expect you to be very polite to your adversary as well as to the court and everybody. If you've been a regular practitioner in state court, this is completely different. Your people are very nice, very friendly, but at the same time, they're very, very disciplined. You're going to see discipline at the highest level. But I tell people, if you have a hearing in federal court, if the judge is calling you at 9 o'clock, you better be there at 8:15 in the morning. So now when you're having the discovery plan, after the initial disclosures, you're there, you need a very good software for that. Something like My Legal Software, you can try it out, the GP speed, but then you can put your timeline together to not miss the dates. You miss the dates, you're looking at trouble. You're missing the date, you're looking at trouble in federal court. And another thing is that sometimes people think that they can file for motions. You can file for motions, but look at the judge's rule before you file that. But repeatedly not following the judge's rule, but repeatedly and egregiously not following the directions of the magistrate of the court, by engaging in conduct that is unethical, by not submitting documents on time, not seeking proper extensions from the court. And I would strongly encourage you, try not to, if you're a new lawyer, only in exceptional circumstances, try to get an adjournment from the federal court. But generally, the courts are not very much receptive to giving you long adjournments. They only give you adjournments when they see that there's a genuine and valid reason. Write that down. Procrastination of the matter continuously can result in a sanction from the federal court. How do you like that, Rahul?
Yeah, I mean, that's very thorough. Sorry, my phone.
Rahul, there's another thing on Rule 11. The next
Yes.
point. The allegations and other factual contentions have evidentiary support, or if specifically so identified, are likely to have evidentiary support after reasonable opportunity for further investigation or discovery. So over here, when you are filing an action, you have to show that you have evidentiary support. You're not going to fly castles in the air by stating that exactly I can do this, I can do that, and there's no evidentiary support. So the courts are going to look at that. What is the basis of our argument? Can you tell us why you filed this case? Or you're saying that the person you gave him $200,000, where's the evidence that you gave him the $200,000? Do you have any witnesses? Or you're just making up stuff over here before the court? That is what Rule 11 is. Like whether you're trying to kind of basically, pull a fast one on the court. When that thought occurs in your mind that your client is coming to you and he's telling you that, hey, listen, I want you to file a case in federal court, be careful. The first question I want to check with him, how many lawyers have you met in the past? And if 4 lawyers haven't taken up the case, only if you're a well-known lawyer, you would take it up for sure. But if you're new, then be very careful. That's kind of an indicator by the very fact that there's something that, there's a lot more than what meets the eye over here. Now, the last one, the denials of factual contentions are warranted on the evidence, or if specifically so, identified, are reasonably based on a lack of information or belief. Now, can you talk about this? The denials of factual contentions are warranted on the evidence, or specifically so, identified, are reasonably based on a lack of information and belief.
Yes, and any denying of any like allegations or factual contentions made against you, you either have to have a basis, that it has to be warranted by the evidence to make that denial, or you have to reasonably believe based on your own beliefs and maybe a lack of information that it is that your denial is grounded.
All right, so what lawyers should do now is when you practice federal law. So let's go back to the basics a bit. Number one is always go to the website of the court, like the Eastern District or the Southern District of New York. And after you go to the website, learn the basic requirements of the site. And when you are practicing federal law, even if you haven't been to that court before, and before filing, look at what I'm doing. Before filing, I'm going to the website, I'm reading about all the judges' rules, I'm reading about the court procedures, I'm reading about all the forms which are properly needed. Those are like, the basics. Then I would read about one magistrate's rule because most of them are similar. And the same thing I would read about one other judge's rule. So at least you have that mental kind of peace that I know what I'm doing. Look, if you're a new lawyer or if you're practicing in federal court for the first time. So the basic tools of the trade, federal law civil procedure. Second is magistrate rules, judges' rules, and then electronic filing to make sure that you're good with the basics. So you have that peace of mind. And fifthly, substantive law. Other than that, I would also encourage you to do some good research. And you can also go to PACER. And you can even look at the other case laws on the point of how lawyers are filed and what have been the decisions in those cases. PACER can be a very helpful tool for lawyers to avoid Rule 11. Trust me. And secondly, for experienced lawyers, if already there's a case law on point, I have a simple formula that I follow. This is my personal my personal thing, and please do not hold me to this. I generally look at if I want to create some new case law on the point, I at least make sure that there is at least a 33% difference in that case law and my case law, because I leave that extra bandwidth for me to argue that why that case and my case is different. This is where exactly good lawyers kind of basically differ, because you have to create case laws if you're a good lawyer. And therefore, knowledge of substantive law is the key for you before you even kind of get to that level. Substantive law, read case laws on the point, look at the Second Circuit decisions, look at Ninth Circuit, if you're in the Ninth Circuit, those things are critically important for you. But the biggest mistake you'll commit is if already there's a case law which is identical 100% on the point, you're just going to get nowhere. You're just going to get a slap on your wrist. So either the court may tell you withdraw or get ready for a sanction. Rahul, your thoughts on that?
Yes, I mean, if you can't argue that the law should be extended and there is, substantial existing law on the point, then, you have to either show by a non-frivolous argument that the law should be reversed in some way or modified or extended. Otherwise, yes, you are at risk of sanctions. You're in violation of Rule 11B.
And Rule 11B is far more kind of serious than Rule 11 on the whole, as you all know. Now, few other things is that the importance of being organized in federal court. Now, you went for the Rule 16 conference, and you got these A, B, C, Ds to do. It's good for you to have a legal software wherein you can put everything in one place. And in my legal software, they have it was developed by lawyers to make sure that you have a proper game plan and you can get proper notifications over there. Put in your case notes, put in your notifications, and the notifications also go to your paralegal over here so that you don't miss the deadline and you also get notifications before the date. So what happens with those notifications? That's what I use my legal software for here, because we do a lot of federal work too here. So those things help us to keep track. And I look at my cases on my legal software. So I know this case is coming up. I have a fantastic kind of this. Then also sometimes I want to have a quick Zoom meeting with my adversary and I send him the link from here. I get in touch with him and my legal software comes in, I update my case notes and I'm good to go. And at the same time, what I do in some cases is that I have to keep track of my hourly billing. So my legal software also has the hourly billing feature. So immediately I track my time, I put it in. So I have a proper record of things. So when you're in federal court, sometimes, you may be asked, how many hours did you put in? And the adversary may ask you, come on, let's settle the case. We're ready to pay the attorney's fees. Hallelujah. Great for you. So now, half the programs which are out in the market, they're telling you have to pay extra for having this hourly billing software. This is included in my legal software. So what my legal software has is like it's a complete portal. And remember, one common question we got from people that is this only an immigration software? The answer is no. It's meant for general practitioners. There's a separate version. And for immigration lawyers, that's a separate version. And for people who practice immigration and general practice, they have a special plan for that too. So And it's not very expensive. People can try out other softwares and see the difference, because even Rahul worked extensively in the development of the software. And he's put in this time and effort, because you can see Rahul's knowledge and he can talk to you like a walking book. And many other lawyers did put in their time to see. And this was developed over a period of time. And whenever Rahul had seen that this is an issue, he made sure that he included that piece in the software. So this is the difference of how my legal software was developed. It's not an ordinary program, folks. When you look at it, you'll understand. But my legal software is meant for the serious legal practitioner. It's not like those baby programs which are out there to maintain your deadline. This is something which has been made for lawyers who basically, like to practice very meticulously. Lawyers who want to see that whole damn portal in front of them. They want to know that I am driving a Mercedes-Benz. I have everything here. So that's how exactly we tried our best to make it more like a Mercedes-Benz. And thanks to the many lawyers who actually gave the feedback in the development of my legal software. And around one other thing I like is the case notes feature. And sometimes there are clients over there who come in and they say that my lawyer, I'm talking about Rule 11 here, never met me. My lawyer never called me. Pull up the case notes feature. Show the record to the court that what this client is now saying is incorrect when you're filing a motion to withdraw. And that is a business record. And you can also show them the correspondence through text messages that you send the client, which is included here. It can become a lifesaver for you folks. See how I'm relating all these issues to a software here. And another thing, your client, you're in urgent need of talking to your client. Simple thing is just send him the link from there. He gets the link and he's talking to you via my legal software. So, and you're writing notes, you're even finishing up your legal brief as you're talking to him. Endless possibilities are there. And your calendar is also synced with Google. So you're looking at that entire 9 yards has been taken into consideration in the development of the software. Of course, you can never find a perfect software in the world, but we tried our best to make it as close as possible, Rahul. Do you agree?
I agree.
And Rahul is a
very
graduate from Georgetown University, and who's been in doing this for more than 8 years or 9 years. How many? 8 years? 9 years? 9 years.
8.
So I was pretty close, Rahul. So now there's one other thing that comes to my mind about Rule 11, Rahul. Do you know that the model code of conduct, as well as the rules of ethics, are very much related to this?
Yes, because it relates to the propriety of legal profession. I believe you're muted.
Rahul, you can continue talking.
Okay. Yes. Because it's related to the propriety and the ethics of the profession. Sanctionable behavior is basically behavior that is improper. It's intended to harass. It's not to advance the litigation, to maybe cause unnecessary delays in it or increase the costs of it, or involves making frivolous arguments that don't have a basis in the law or in the factual record. These are all issues with the practice of law and diligence, as well as the federal rules of civil procedure.
So now let me cite a rule for people who want to really have a thorough understanding of Rule 11 and how it relates to the rules of professional conduct of the American Bar Association. Rule 3.1 of the rule states, a lawyer shall not bring or defend a proceeding or assert or controvert an issue therein unless there is a basis of law and fact for doing so that is not frivolous, which includes a good faith argument for an extension, modification, or reversal of existing case law. A lawyer for the defendant in a criminal proceeding or the respondent in a proceeding that could result in incarceration may nevertheless so defend the proceeding as to require that every element of the case be established. So the only exception is basically in criminal law. They're giving you some room because, as you rightly know, in a criminal case, the proof has to be proved by the prosecution beyond reasonable doubt. But in other cases, when you already know that what you're doing, that your conduct is egregious, now this is the word I use, as a lawyer, there is no basis of fact for this federal action. No basis. Absolutely no. And take an example that you're filing a case under the Fair Labor Standards Act in court, and your client had only like basically, this other entity only has two workers working over there. And instead of taking it to, state court, you took this action in federal court. The question is going to be, excuse me, why are you even here? You may say the Fair Labor Standard Act apply, substantive law. But did you check that there's an X number of employee requirement before you take it to federal court? Look at this carefully. If you're an immigration lawyer, you're filing a mandamus, and it's just been 2 months from the case is pending, and your client is pushing you, oh, please do this for me. Please do this for me. My mother's very sick, and I want to make sure that I do this right now. You would not do that if you're a good lawyer. Because the first thing I would do as an immigration lawyer, I would make sure that I would look at the processing times. And if there are no processing times, then I would look at unreasonable delay, which means I would look at how long it took for other cases to be decided from friends, or you can go to chat blogs and everything. But you're making a fool of yourself in federal court by filing a mandamus because there was no unreasonable delay, and you can be sanctioned. You may be sanctioned because what you did was wrong. Secondly, another thing is that when you're taking it to federal court, especially when you're filing asylums in the Second Circuit or in any circuit, please be very careful. Please be very careful. The reason is some lawyer, your friend of yours, is going to tell you, hey, listen, I have this great asylum case, and the Board of Immigration Appeals has given a very, very long decision by stating that this case already looks frivolous, and we have a frivolous finding over here. And at the end of the day, we have evidence to show that this is a frivolous case, because this respondent is lying to us that he came within 1 year, but we have proofs over here that clearly show that he's been in this country for 13 years. Now, this client is coming to you, telling you, hey, listen, I lost this case, just out of basically kind of, taking up the case for heck of it. I'm being polite here, so that you can get a good retainer. You're taking up that case, and you're taking it to federal court. Remember what I said about Rule 11? They want you to look at the evidence. See how I'm relating the rule with the facts now. If your friends have missed something today, I'm sure you're going to tell all your friends to attend this session. You will not find this information anywhere. Now, when I'm doing my research, when I'm talking to my client, I'm looking at the evidence. Now the client tells me, in reality, I told that lawyer that I was here for 13 years, but he put in 1 year. Do not even take up that case. Because now when you're going to go to federal court, the judge is going to tell you, excuse me, sir, did you read the decision of the BIA? Did you read the fact that they were able to show the driver's license of your client, which was issued by the DMV 13 years ago, and they were even able to show a criminal record wherein he was caught for drunk driving, that he was living in this country. They may even go to the extent now of showing an IRS record that he filed taxes here, and you're telling me that your client was here for 1 year. Are you a lawyer? Are you joking in this court? Are you trying to waste our time? Straight sanction. These are factors. These are examples I'm going to give it to you today. So my legal software can be very helpful. We have people like Rahul who can help you out if you ever stuck. More and more lawyers are joining my legal software. They're taking the demos, they're coming there, and they're seeing the difference. And as I said, there's a big difference in this company because just as a voluntary basis, we help lawyers out with simple questions. So feel free to reach out to my legal software at 934 Law Tech, 934 Law Tech. It's very easy. And my legal software has website development programs. If they can also increase your business by actually, kind of doing your digital marketing. And they do our digital marketing. As I said, again, for disclosure purposes, I am the founder of the company. So I want to be a straight shooter out here. There's no hidden agendas when I talk. And we get a lot of clients because of the digital marketing program that we have, but I cannot guarantee results, being too ethical as I talk. And secondly, at the same time, we get a lot of SEOs and everything, and the team of My Legal Software does it for us. And I'm proud to say that at Gay and Associates, we are using My Legal Software, and we have 18,000 cases in our database so far, 18,000. And our staff has grown up to 100 people internationally working for us. So yes, there are softwares out in the market, but you really need to try to believe it. And they have a free promo going on for some time. You need to call to check with them. So that may be very helpful. Now, when you organize your data, the calendar of My Legal Software can be helpful. So can you tell me, Rahul, how the calendar can be helpful? And let's talk about the importance of Rule 16 and the calendar here.
Right. So the calendar is imperative for scheduling, especially in federal court, where you can't miss, hearing deadlines or, deadlines for submissions prior to any hearing, or a motion as well. Mr. Gay mentioned letter motions previously. And so the calendar is a way for you to both input all of the deadlines for a specific case and also see your deadlines in general for either the entire office or a specific case worker. And you can put in different types of events, say like a hearing.
So discovery is coming up, for example. Went over there and your discovery is coming up, your depositions are coming up, and after that, your conference is coming up before the court, and your settlement conference is coming up. You can align them properly.
Exactly, and you can see basically a timeline of how the case is going to progress.
And the other thing is that you can set your internal deadline too. That's what I like about My Legal Software, so that you actually don't miss the actual deadline here.
Yes, you can, for specific tasks related to it, you can break down into your calendar, not just, the final deadline, but internal office deadlines for different aspects of, the ultimate
Can you
filing.
show them exactly a bit of the My Legal Software thing?
I think, Amresh, yes, can you pull up the My Legal Software calendar, please?
Thank you, Amresh. Amresh? All right. So, Rahul, can you talk about it a little bit of
Sure.
how this works?
So here at the top, you see different sets of filters. This is for one particular firm that has, say, one kind of event for courts, one for follow-ups, one for initial, one for USCIS submissions, one for other. And you can organize and input, you can basically filter and just see your court appearances, or just.
Now, let's take an example about a lawyer, right? We'll take an example about this is about the immigration speed. So let's talk about an immigration lawyer who's filing a case right now, a petition for review of naturalization proceedings in federal court. So this is what we need to do is the type of court, and by the type of court, you'll be able to kind of go to the court and you'll be able to put the deadline, whether the deadline is on Wednesday, what your hearing is all about. And you can create an event over there on the right-hand side over here to put it in over here in the event of what exactly event is coming up. And, talk about that, Rahul.
Yes. So basically, you can start from when you actually have, say, your hearing for naturalization. You can set the 90-day deadline for when you would be eligible to file a suit in federal court. And then from the complaint, which you could also put in the calendar, you could then basically schedule out how the remainder of the proceedings are going to go from the start. And you would be able to see them all in front of you. You could filter for the specific case, or you could have, your entire schedule for that day. Or for the month laid out in front of you, regardless of what case it belongs to. So you can see where and when you're overbooked and adjust your deadlines, especially your internal office deadlines, accordingly to get some work done ahead of the, any log jams that may arise.
Right. And Rahul, one other thing which I like, since they pulled up this immigration kind of board today, next time we'll be explaining the general practice board, which is different. So now also what I like about this is that if I practice deportations, and which means removal kind of defense, they have a removal defense calendar. So, where would that be? And can you show us that? Or?
Yes. So for any particular case, when you're creating a case, you can create an event. And one of the kinds of events that you'll be able to create have to do with immigration court. They have specific deadlines for, say, call updates. And when you get assigned a judge, you can look up their individual rules or
right, so
their requirements.
We can go to the calendar way, right? Where can we find it? So we can ask Amresh to pull up. Is that in calendar web? Where can we find that?
Yes, I think in the demo site, yes, it should be here. If you go to my cases or
Yes.
and pull up a case.
Pull up any case, or you put a case number on top. So Rahul, let's continue talking until they do this.
Yes.
And so let them work on this. So we'll continue talking. So Rahul, now we spoke about the ethical implications of an attorney violating Rule 11. So the common issues which I've seen that some judges are nice, and what are sanctions? People are always scared to show what are sanctions over here. So sanction does not by itself mean that you're going to be sent to the disciplinary committee. So that's the biggest worry that people have. And sanctions cannot be arbitrarily imposed by the court. Arbitrarily means like exactly they cannot just go up for a sanction the way you want it, that it's going to be. They will have to apply standards based upon the gravity of the mistake, is the exact word. So if the gravity of the mistake is kind of egregious, then the sanction level is high. But if it's a minor error that you try to kind of waste the time of the court, they may ask you to pay $500, and your first time sanction will be kind of reasonable. It'll be mild. Or if you're sent before the bar committee, they may ask you to take a CLE, or they may issue an admonition. But if your conduct was egregious, which means if you conducted any kind of forgery, or if you filed a case which has zero merit, and you are trying to harass your adversary, you started harassing the law clerk, then in those cases, I think it's going to be kind of a lot more severe, I believe. Rahul, your thoughts on that? So, Amrit,
Yes,
thank you so much. And back to the session. But if people want a demo, they can get back to you. And you can close the screen. Let me continue with Rahul right now.
Yes. So one of the issues is that the goal of any sanctions that are imposed is to deter sanctionable conduct. It's not necessarily to punish past conduct or compensate the victims of improper conduct. It's just to be enough to deter future sanctionable conduct. And so a number of factors will be taken into consideration, your history in the litigation, evidence of, a good faith or a genuine mistake or a genuine belief that, your arguments are not frivolous. And all of those will combine to determine what the outcome is. In some cases, it could just be, say, if you had been filing an excessive number of motions, then you may have to ask the court's permission before filing any future motions in that case, or you may have to cover the attorney's costs and the expenses of any effects of your sanctionable conduct. There is a range of sanctions, and they will depend on a variety of factors.
Yeah, so the range is like right from a CLE, right from basically kind of reporting it to the bar committee, grievance committee, if it's very egregious, like forgery, and you stole money from escrow, and the settlement was given as escrow $2 million. You did not give the money, and the client goes to the court and say, hey, listen, the settlement was $2 million, and the lawyer took the money. That can also mean jail time. The federal judge has the right to report you. And thirdly, being very, very rude to the court, being kind of using obscene language to your adversary, and screaming, yelling, shouting in court, not allowed in federal court, folks. Calm down. Respect is the number one thing which is looked upon. And the easy way for you to practice is always say good morning to your adversary, say good morning to the court, and be honest enough to let the judge know, I don't know, judge, I won't commit this mistake next time. Next time, the judge will be a bit upset, but they're human beings. They'll tell you, okay, next time you better be prepared. So things happen, but I tell people that before you have your federal court hearing, make sure that you know your facts very well. And just a tip to new lawyers and people who have practiced state law and they want to go to federal court. In state court, I've seen lawyers just walking up at the last minute seeking adjournments. Please don't expect that in federal court. At least 48 hours before your court is, I would say like at least a week before. See whether everything is perfect in the court. Now, this is very important for you because even if you're seeking an adjournment, last minute. In most of these federal, kind of state in federal districts, the rule is that you have to approve them at least 48 hours before. So don't even think. And the other mistake that lawyers do, they reach out to the judge's clerk with that mistake. It's written in the rule book. Only if it's an emergency, the clerk wants to be kind of bothered. But please do not bother the court clerk again and again, but the judge will be upset at you. Oh, these are some things which I've learned from my experience, from my practice, after reading a lot as to what is so different than federal court. And it's great to be a federal lawyer. And sometimes folks, believe it or not, judges are wrong. Sometimes, because they are human too. But as a good lawyer, you have to be polite enough to let them know, I respectfully disagree with the court. And they'll smile at you. They'll tell you why. Because no human being is perfect. And most federal judges are wonderful. But one thing which I've learned over the years, sometimes even when you're right, tell them, okay, Judge, you are correct. And learn to bite the bullet if you're a good lawyer. Trust me, seasoned lawyers who are going to watch this, they are going to love this. Because one thing which my mentor taught me before I got into federal court, an eye for an eye makes the whole world blind. An eye for an eye makes the whole world blind. So if you're not happy about something, let the judge know that I would like to submit a letter motion. And they'll give you an opportunity to, let them know, Judge, may I have the opportunity to serve a memorandum of law on this issue. That's the way of how you talk. That's the way of how you kind of balance it out. And, that's how exactly federal law should be. Sometimes you'll come across some great federal judges, but some of them may be kind of very different to you. So it all depends on the judge that you get sometimes. But be prepared for any kind of judge, but have a cool temperament. If you have a cool temperament and you're fully prepared, if you have the law on your side, if you have the facts on your side, if you have the right tools of the trade, I can promise you'll go a long way. So a lawyer, any questions, folks, please feel to ask us questions because this is a very important subject. And if anyone has any questions, feel free to kind of add your questions. So we'll be happy to talk about it. Rahul, should new lawyers be scared to go to federal court? My answer is no.
No, I don't think so. As long
They
as
need
they're
the right training, they need the right guidance. And if you're filing your first mandamus, or if you're filing your first case in federal court, you're filing a complaint, My Legal Software can help you out. The number is 934 Law Tech. Or you can go to mylegalsoftware.com. And it's all over, on the internet. You can find mylegalsoftware.com. And, if you're a member, then we'll be happy to help you out with legal research. We cannot give legal advice if you're in some other state, but we can do legal research for you for sure. And that's something that we do. And lawyers are very happy about it. And a lot of law firms that practice state law, federal law, immigration law, bankruptcy, divorce, personal injury, they are considering My Legal Software. So some other thing, Rahul, that I'd like to say is important rules from the federal court. Some of the important rules, from the federal court as follows. Rule 11, of course. Rule 16B, very important for lawyers to know. If you practice class actions, Rule 23 is very, very important. And if you're into Fair Labor Standards Act, you should know Rule 68. And of course, the rest of it, there are some cases which I always tell people to look at the matter of Tomlin and the matter of Iqbal, IQBAL, TOMLIN is very important for you to understand the jurisdiction of the federal court. So those two cases should always be read by a lot of lawyers, or it doesn't matter which circuit you are in. Tomlin and Iqbal is something that I recommend lawyers to, study very well. Now, one other important thing, I think people are liking this very much. I'm getting some messages here. Thank you for listening to this, and also let your friends know that we'll be conducting a series of different topics on federal law, and we'll be talking about Rule 16 next time, Rahul. What is, our next topic on federal law is going to be the importance of Rule 16 for new lawyers, especially. and how to file your first action in federal court. We'll talk about how to file your first action in federal court, and we'll put in a lot of emphasis on the federal rules nowadays, so that lawyers actually learn. So the next thing which I was trying to talk about is an important rules that you have to know, which we discussed it. Now, even after knowing the rules, the knowledge of substantive law that you have should be unparalleled. Because when you're going to be in the court, the judge can ask you any question about your field. Under what section of the FLSA are you talking about? Judge, I'm talking about Rule 216B, wage and hour claims. Okay, so what happened? My client was not given overtime over here. So are you seeking class certification? Okay, I am. What are the basic requirements for a class? Numerosity, and that you'll adequately represent the class, and that basically that you have enough number of people in the class and whatnot and everything. Then the next thing the judge may ask you is that have you checked the evidence in your case? The good thing in labor law cases is the writing is on the wall. That the burden of proof, if your client doesn't have the records, it's actually on the defendant. So that's one good thing I like about the wage and hour claims, that you don't have to have all the records. The records come out over there. And sometimes the defendant's lawyer will try to scare you in wage and hour claims by stating that no, your client should have. As far as your client has a basic understanding, you're fine. And if you're dealing with undocumented immigrants, you don't have to worry about it. Because suppose even if you're practicing immigration law, and if you are suing a private employer, in a discrimination case or something, he cannot threaten your client. Remember, this is where sanctions come in. Now I'm teaching you how to use sanctions as a sword if you're a lawyer. So now you're actually kind of dealing with a case wherein an undocumented immigrant was discriminated by a company. And you have evidence to show that they use all these nonsensical words against them. They told them, go back to your home country. We don't like you. You should not be here. You belong to so-and-so race. You're a ABC and whatnot. Now you filed a case against this particular company. Now he's represented by a lawyer. And now that lawyer doesn't know immigration law. Look at that. The defendant's lawyer, he calls you and he's telling you, hey, listen, I know your client doesn't have papers. And if your client is going to continue these papers, I'm going to get him deported. The lawyer, the defendant's lawyer, violated the code of ethics. Use threats to settle the case. And you should immediately move for a letter motion to the court for sanctions. And in this case, the court can award you cost and attorney's fees. And the lawyer will be warned that you cannot do this. See of how Rule 11 can also work in your favor if you're a good lawyer. So understanding Rule 11 is important. It can be used as a shield as well as a sword. It can be used as a shield and it can be used as a sword. And if you're an attorney and if you want to take your practice to the next level, my legal software can help you to handle your website, and they can do digital marketing for you. Because remember, half the people who are lawyers who are having the digital marketing sites, they don't have people like Rahul at the back who know what keywords are important. They're just paying the money and saying, okay, and that guy doesn't know the law and he's putting in any random keywords, and you feel your site is not coming up because he is not marketing your site properly. So my legal software takes those precautions to make sure that your site is properly handled, the right keywords are given over there, the marketing is done properly, and your digital marketing, when you're doing that, you need to make sure that you have those keywords which are actually important for your site to come up. You're spending these thousands of dollars without getting any hits. Sure, because you have people who don't have a legal background handling your website. Of course, no one can guarantee you results, but be safe rather than being sorry. And your digital is taken. Now, the other thing is that, is your website ADA compliant? Folks, if your website is not compliant under the Americans with Disabilities Act, you need to read the ADA, because if a visually impaired person comes on your site and if he cannot read it, you may be subjected to a lawsuit. You may look up the law, you just need to Google it. And you must see the amount of money that companies are spending just to settle those cases in the thousands of dollars. So my legal software can help you to have an ADA compliant website. They can handle your digital marketing for you. They can handle your case management, which is one of the best things that even we use. As I said, open disclosure that I'm the founder of this company, but it took years and years to develop this program. Fantastic for immigration lawyers, fantastic for general practice lawyers. So, folks, if you have any questions, we'll be happy to listen to you. So now, next topic for us, Rahul. We are going to talk about cybersecurity again. So that's a big issue. And, in that we're going to focus on how it's important for people, like, when even they file in federal court to redact certain information like social security numbers and to redact the personal information of the client. And all these are very much related to the security of the client, because even these things are a part of cybersecurity. Rahul, do you agree? Because
yes, absolutely.
Just openly, you can talk about that a bit.
Yes, I mean, anything that's at risk of a data breach is, part of cybersecurity. Anything that you store in a cloud-based, system, any digital records that you keep are all at risk of, cybersecurity threats.
So we'll be talking about, some federal rules as well as, cybersecurity, which is a burning topic right now. And my legal software is very much prepared to help lawyers to analyze the security, because the security of a website is also very important. Because I'll tell you why that is important. You have the site and you're allowing your client to access it with case number 20101012. Okay. Over there, when he goes and he doesn't find his data is lost, you're in trouble. Or his entire case pops up on your screen over there and the world can see it. Be careful, those things have happened. Because your software, your website provider did not have the right plugins on your security. And all the data right now, once your website is down and the guy is saying, I don't know what happened, because he did not have the proper security tools. Half the websites that we see, Rahul, they are not even HTTP secured. Lawyers don't even know, some of them, what is HTTP security. And Google is giving them this thing over there. Do not visit the site. The first thing is you're losing clients. Number one, people are not going to come to your website. And even if your web guy is apologizing to you, he doesn't know what he's doing. Second thing is your website is not ADA compliant. Thirdly, you're not getting enough clients because he's saying it's going to take 8 months, 12 months. Please don't buy that baloney. Should be done with him. Other than that, he's saying, I'm marketing. You're not seeing clients at all. You're seeing the wrong clients coming to your office. That's a red alert right there for you. So, folks, it's been wonderful being on the show. I need to thank Ravi, Amresh, Mike, and of course, Pianjali, who does a fabulous job. Needless to say, Rahul, you're just doing a fabulous job. So if you need any demo for my legal software, if you're thinking about building a site, or if you want to change your site, update your site, or you need more business for digital marketing, make sure that you have people who know the right keywords. You cannot have someone like Rahul look into the keywords that you want, will be your kind of point to person to make sure that we get the right things in order. You can ask for Rahul, and he is just absolutely brilliant. Wonderful man from Georgetown Law School with 8 years of experience as a law clerk under his belt. And he is very much into law of technology with Priyanjali, with Ravi, with Amresh, and with Brian and the rest of the team. So, folks, we'll be back again next week. We're going to have another webinar. So if you missed it, your friend missed it, circulate this tape, especially for people who want to learn federal rules. As I said, as far as this was a very special thanks to, again, my legal software. I'm the founder of it. This has no connection with Gay and Associates. I'm speaking basically as a speaker on behalf of my legal software and Rahul and I. Rahul is a law clerk and I'm an attorney licensed to practice law in the state of New York and in Connecticut only. So we'll be back again next week. And for more information, visit mylegalsoftware.com, mylegal software.com, real easy, or call 934 Law Tech to schedule a demo or speak to a representative. Thank you for your time.
Thank you.
Next week, mark your calendars, and next week is going to be the 9th, I believe. We'll be back on the 9th. Mark your calendars, same time, 9th at 3 p.m. Thank you, everybody.
Thank you.
Thank you all. We'll be